Today we're going to look at the difference between a mechanic's lien and a civil lien for getting a title for a vehicle. If you have a vehicle that is missing a title, maybe it's been somewhat abandoned or left on a property, maybe you did some work on it, maybe you repaired the vehicle, maybe you towed the vehicle, and you need to get a title because the owner is not coming forward with the proper payment, or maybe the owner is just MIA. You have a couple options. You could do a mechanic's lien or a civil lien, and we'll look at each one and what the differences are. First of all, mechanic's lien uses your authority as a licensed automotive business. So in most cases, almost all 50 states, you have to be a licensed automotive type business, a repair shop, a body shop, a towing company. And in almost every state, those types of businesses have a very specific type of license. It's not just a business license, it's an automotive license. And that license gives you a lot of privilege to do a mechanic's lien. If you don't have that type of license, a civil lien might work, but we'll look at both of them because some of the aspects of a mechanic's lien are important to know about for a civil lien. Mechanic's lien clears all bank liens. So if somebody brings a car in for service and they don't pay their bill, but they owe $10,000 to Bank of America, a mechanic's lien will wipe that lien off the title if done correctly. And it gives you the money to pay the repair bills that were not paid. What are the disadvantages? Well, as we said, it requires an automotive license in almost all 50 states. There's one or two states that don't, but even in those, there might not be options for you. It must be done within a certain time period, meaning that the state law that allows you to do a mechanic's lien requires that you start it within a certain period of time after the bill is due. So let's say the bill is due on January 1st, and you tell the customer, hey, look, you owe me $852 for transmission and another $250 for storage fees. Pay the bill. And they don't pay the bill. You can't sit on that car for 2 or 3 years letting bills rack up or letting the customer disappear before you start the process. Every state has a requirement that you start it within a certain period of time to protect the interests of that customer. So if you don't start it within that period of time, you may find that all the work and effort you do on that paperwork is wasted because it's rejected once you send it in. In most cases, you must have a signed repair order from the vehicle owner. You can't just have a verbal statement saying, yeah, fix my car. You have to have a repair order, or what's called an RO, from that customer signing to say, I authorize you to do work on this vehicle. Because if you don't have that, anybody could just make up a mechanic's lien, and it doesn't protect the interests of the owner. Requires proper notice to the lien holder and owner. So if you're doing a mechanic's lien, the first thing you need to do is send a very specific type of notice to the owner of the vehicle and the lien holder, advising them that you're intending to lien their vehicle and to take ownership of their vehicle or sell it. That notice has to go to a certain location address for the owner and the lien holder. You can't just use the address you have on your repair order or what you found in the glove compartment. You have to send it to a certain location and document it so that when you send in all your forms to get a title, they can verify you sent that notice properly. Requires the vehicle to be offered at a public auction. So you have to allow the general public to bid on the vehicle before you take the title to it. Now, in most cases, general public, nobody shows up to bid on it. And even if they do, normally you can just bid on it yourself because the money's really not going to anybody but you. So that may not be as big of a deal, but just keep in mind, it does have to be presented to the public. It may not cover all storage fees. Most states have laws on the books and part of your automotive license that puts a limit on your storage fees. Maybe a limit on the number of days. Maybe a limit on the amount per day. You also normally cannot start storage fees until you start the mechanic's lien process. So you can't just rack up 3 months of storage fees and then do the mechanic's lien. It starts from when you start the mechanic's lien. These mechanic's liens can be rejected if you didn't adhere to the license requirements. Things like getting a signed repair order. Things like having the vehicle remain on the premises. Most times the vehicle has to have remained on the licensed address for that premise. There's many other things in your automotive license that you have to abide by, and if you didn't abide by them, it can be rejected. So, is it common to be rejected? The answer is yes. because the DMV, or the titling authority, knows that a lot of these mechanics liens are done kind of improperly. Sometimes they're even done fraudulently. Automotive businesses who have a mechanic's license have a privilege, and a lot of times they'll abuse that privilege. They'll tell their buddy, look, I got this license. If you need a title for a car, give me the VIN number and I'll file a mechanics lien on it, right? So a lot of these are scrutinized more, and you might get rejected. Now, what about a civil lien? A civil lien can be filed by consumers and non-licensed businesses. So if you are an apartment complex, if you clean out properties for foreclosures, if you maybe gave somebody some money for repairs, or you stored it on your property, you don't have to be a licensed automotive facility to file a civil lien. That's why it's called civil, because civil is like a civilian type of authority. It overrides DMV requirements. That's an advantage because a mechanics lien goes through the DMV. So you have to abide by Department of Motor Vehicles requirements. Now, some states, what we call DMV is called something else. For example, in Pennsylvania, DMV is called PennDOT. Or some states it's called Bureau of Motor Vehicles. In Illinois, it's called Secretary of State. Whatever licensing, titling authority in your state has certain rules. When you do a mechanics lien, you abide by the rules of that titling authority. When you do a civil lien, this overrides all of that. The authority you get can bypass all those requirements. It also bypasses the document requirements. So you don't have to fill out any certain forms or notifications. On the mechanics lien, there's usually 5 or 6 forms you have to fill out. Official DMV forms have to be done the right way and be notarized. Civil lien, you don't have to file those forms unless the clerk tells you do. It can be done in your local county. For a mechanics lien, a lot of times you have to send this into the main office for the DMV. So if you're in Texas, it would go to Austin. In every state, there's a main office for the DMV. Some states it's not the capital, like in Connecticut. It's in Wethersfield, not in Hartford. So you can do a civil lien in your local jurisdiction, in your local county office where the clerk is. There are also no filing deadlines, meaning that if this happened 2 or 3 years earlier, there's no immediate rejection of that because you didn't meet the filing deadlines. And there's no formal notices or prerequisites involved. Like, you don't have to have a signed repair order. You don't have to send out notices to the owner. Now, the magistrate who signs off on this civil lien, they might require some of this, but it's not by default a requirement of filing this civil lien. What is the downside? Well, it might require that you go in person to the courthouse. Sometimes you can't do it by mail. Sometimes you have to bring the documents to the courthouse or appear in the courthouse in person. It also could take longer. The court calendar could be weeks of delay. Although a mechanics lien, you have to wait usually 45 to 60 days after the notices anyway. So a civil lien might not take that much longer, but it's up to the calendar docket of your local jurisdiction. And you'll get a date. When you file it, they'll tell you the date that you have to have everything in by. Or if you have to appear in person, it'll tell you that date too. The other downside is this. This is the big one. There are no pre-formatted documents to fill in. Like when you go to DMV, they have a certain form with blanks. For example, here's a typical DMV form, right? You'll see there's blanks on the form where you just fill in empty spaces. Well, a civil lien, there are no fill in the blank forms. You have to start with a blank sheet of paper with nothing on it and type up that civil lien, what's called a petition. It can be a little tricky, but there's ways to make that easier. But that's definitely a downside to a civil lien. It definitely starts with a less user-friendly documentation process. What are the steps of a civil lien? Well, first you make that petition. You type up that petition. It's called a petition or a complaint, depending upon your jurisdiction, and you file it with the clerk in your county. And it'll be stamped of a date, stamped of a time, and it'll be put on the docket. You're going to get a notice, maybe immediately, maybe within a week, of when your deadline is. And on that deadline, you have to either bring documents in, mail documents in, or appear. at the court. And what do you have to bring? Well, there's some DMV title paperwork that you'll need. Some of these fill in the blank type forms. You'll need some of these. You will also need an affidavit of facts, meaning that you'll have to have a statement of how you acquired this vehicle. Okay, on this date, the vehicle was in my yard. I gave the guy some money. I bought some parts. Whatever your story is, and it doesn't have to be that formal. You can say it in your own words, right? We recommend either writing it down or typing it up on a simple word processor so you have that statement of facts with as much detail as possible, because that's going to be your ticket to getting that signature for you to be the owner. And once you have those, you'll have to submit those by that response date. Again, sometimes the court will say mail them in. Sometimes they'll say just bring them into the clerk. Sometimes they'll say you have to appear on this date and time to not only bring them but present your story to the clerk. If the story makes sense and there's no prohibiting factors like the vehicle's not reported stolen or somebody's not looking for it, then what you're going to get is what's called a judgment of ownership, where the court authority, a magistrate, a judge, a clerk, whoever signs, will sign that judgment of ownership. Basically, that will be your golden ticket. That will say officially you are the legal owner of that vehicle. Officially. You can take that document down to the DMV, slap it on the counter and say, this is my car, give me a title. You don't have to have the old title. You don't have to have a bill of sale. You don't have to have a mechanic's lien. If you have that paper signed by the court, by the magistrate, whoever does it in your county, that overrides the DMV, that overrides PennDOT or the Bureau, whoever issues titles. It's like going over their head. So if you've gotten the runaround from a titling authority and they're dragging their feet and you just can't get through to anybody, a civil lien goes over their head, and you have that document, you slap it on the counter, and you now have a title in your name. Now, keep in mind, we're not attorneys. We're not giving you legal advice. We're not, telling you that your particular case fits this profile, but this is a good, some people call it last resort. Some people call it first resort. It's a way to overpower that bureaucratic DMV system to end up getting a title certificate, which is what you want. You want a title certificate. You don't want the runaround from the DMV. And this is a way to overpower all that to get a title in your name. Now, questions, very common questions that come up. How much is this going to cost me? Well, usually it doesn't cost that much. If you do the whole thing yourself, you might pay, a court filing fee, 50, 70, 80 bucks. We've seen a few states that are a couple $100. You're going to have to pay your regular title fee. Whatever the title fee is in your state, most states' title fee is, 30, 40, 50 bucks. You'll have to pay that regardless. This doesn't get you out of paying your title fees. And again, if you do it all yourself, that's usually all you have to pay. Now, some states have additional requirements for titling a vehicle. Some states require that you inspect the vehicle before titling. In most states, inspection is not required unless you're registering the vehicle for the road. So that doesn't make this requirement go away. What about insurance? You're probably going to have insurance on the vehicle. In fact, we recommend that you get insurance on the vehicle before you try to do a civil lien. Check with your insurance agent about if that's appropriate or not. The other question is, what kind of title is it? Is it a salvage title? Does it have a lien on it? Is it a bonded title? The answer is no. This process does not add any additional title restrictions to the process. It doesn't add a lien. It doesn't make it a salvage. And it doesn't necessarily add a surety bond or bonded title. Now, in some cases, the civil lien process, the court might say, well, in your case, your story's not good enough, so you have to do a surety bond. Usually not, but the court can say whatever they want. The other very common question is, does it create a clean title? Well, if the title was clean before, it'll be clean after. And by clean, I mean, is it a salvage? Is it a rebuild? Those types of title records do not go away. So if it's already a salvage title, this is not going to wash away the salvage brand. If it's already a rebuilt title, this will not wash away the rebuilt brand. But it's not going to add anything either in most cases. You're not going to have salvage added to your vehicle if it wasn't already there. And of course, There are options for getting assistance with this. Certainly, you could hire an attorney to do it, but that's going to get very, very expensive. We do a lot of these for attorneys. Most attorneys don't want to do this themselves because it's a very inefficient process. It's not a very high-end process. Most consumer clients do this without an attorney, do it themselves, because by the time you hire an attorney and they charge you 8 or 9 or 10 hours of billable hours at $300 or $400 an hour, it could be $3,000 or $4,000 for attorney's fees. You don't want to get into all that. You don't really need to in most cases. Again, we're not attorneys, not giving you legal advice, but most customers will do this without an attorney. And even most attorneys who have clients who come to them tell them, look, do this yourself, or they refer them to a title company like us. And can somebody else do this for you? Well, yes and no. All of these steps that you see on this list, the requirements, somebody else can do for you. We can do this for you, except one thing. Except appearing in person at the courthouse, appearing in person with the clerk. That's not something anybody can do for you. If you want to hire an attorney can do that for you. But no person can represent you with any kind of legal matter unless they're a licensed attorney. So everything else can be done. All the paperwork, the preparation, the filing, the DMV paperwork, that can be done for you. But appearing in person, if that's required, it's not always required, but if it is, that's something you would have to do yourself. And you can't even send somebody else. You can't send your friend or your spouse or your whoever. You can't send somebody else. You have to go in person because they're going to ask you to your face, is this all true, what you said? And you have to say yes. It's a very powerful process. Look, it sounds complicated at first, but when you compare it to what you have to go through with a mechanic's lien or even other title processes like a bonded title, in many cases, it ends up being easier by the time you put all the other steps together for the other process. The only difference is the civil lien, you know all these list of these 7 steps up front. You know it's going to be 7 things. Okay, I got to do this. With a bonded title, you might only see, well, there's only 2 things I have to do. I have to fill out this form and get a surety bond. Well, no, you have to do an affidavit. You have to do a letter of non-interest. You have to do a lien release. By the time you add all the other steps to these processes, they're usually more complicated than a civil lien. And a civil lien is much more powerful. So if you are a consumer and in your mind you're thinking, oh, I want to do a mechanic's lien, and then you discover, well, I'm not a mechanic. I don't have a licensed business. Or even if you have a licensed business, you didn't do it within the right time period, or you don't have a signed repair order. You can jump over to civil lien and look at that as a backup option to get done. Now, is it 100%? Well, technically, it's not. But if you have all of your ducks in a row and you have the proper authority to own that vehicle, that's what this process is for, is to have your story be validated by an authority that can make the DMV listen to you. Because you walk into the DMV and say, hey, I bought this car, it's my car, I got a bill of sale, here's a picture on my phone of the text message of the seller selling it to me, or I got a receipt where I sent them a Zelle payment. The DMV is not allowed by law to make a determination if that's true or not. The court clerk can. So this is validating your story, so the DMV has to listen to you to give you your title. If you have questions, you can reach us on our website. We also have consulting services if you would like to do that first. And if you have any questions, you can reach us at our help desk, Help Back Car Titles. We're glad to be of assistance.